Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call an arraignment. An arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your more serious type offenses, whereas your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm referring to is the facts of the case, and I'm also referring to the possible punishment that a person can receive if they are convicted of the offense that they're charged with. Now, as I mentioned earlier, your felonies and your misdemeanors, with those cases, they are criminal cases. And the offense that you have in this court is a misdemeanor offense. Now, if you had a felony offense, your felonies are divided in 5 categories. You have, and we'll start at the top and work our way on down to the bottom. You have capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you were convicted of a state jail felony, your range of punishment would be minimum of 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If you were convicted of a third-degree felony, the range of punishment is minimum 2 years to maximum 10 years in the state penitentiary, and a fine that does not exceed $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine up to $10,000. If you're convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because your case, as I mentioned, is a misdemeanor case. Now, misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, then you have the Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, your punishment will be by fine only. Normally, the fine is up to from $0 to $500. Now, as I mentioned, you can receive a fine, and you cannot receive any jail time. Now, the Class C misdemeanor cases that I'm speaking of, they originate either in the municipal court, which is a city court, or the JP court, which is a justice court. And if a person is convicted in those courts and they would like to appeal their case, then the case would come to this court. It will still be a misdemeanor, and the punishment range will still be the same, which basically means that a Class C misdemeanor fine is usually $0 to $500. Now, if you're convicted of a Class B misdemeanor, the Class B misdemeanor range of punishment is $0 to a maximum of $2,000. A fine, that's the fine. And the jail time is 0 days to a maximum of 180 days, which is 6 months in the Jefferson County Jail. If you're convicted of a Class A misdemeanor, the range of punishment is 0 days to a maximum of 365 days in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is you have a right to have an attorney. The first document that you have on the clipboard talks about your right to have an attorney. And that first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And you see where it says As a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. That is, you can waive your right to an attorney or give up your right to have an attorney and represent yourself. Now, if you want an attorney to represent you and you do not have enough money to hire an attorney, the case will be reset. Reset means that you will be given another court date to give you time to hire your lawyer or your attorney. If you want an attorney and you do not have enough money to hire an attorney, then you will need to fill out a financial questionnaire. The financial questionnaire is the third document on the clipboard. It is titled Jefferson County Affidavit of Indigence. You'd have to fill out that first page, and I always say 2/3 of the second page. You fill out that second page all the way. You fill out all of the information with the exception of the bottom information where the judge would have to make a determination as to whether or not you meet the eligibility requirements for the appointment of a court-appointed attorney. You don't have to worry about the third page because the court or the judge would have to fill that out. Now, if you want to waive your right to an attorney, that is, you want to give up your right to have an attorney. If you want to do that, you'll be allowed to speak to one of the prosecutors that's in the court. Prosecutors, they work for the Jefferson County District Attorney's Office. They are assistant criminal district attorneys. We have two of them in court. We have Andrew and we have Sarah. And they will, you'll have an opportunity to talk to them if you waive or give up your right to have an attorney. Now, in order to do that, you have to first sign what is called a written waiver of your right to have an attorney. And that is the second document on the clipboard. And it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You'd have to read that document and then sign on the line where it says defendant and dated today's date. And today's date is December 5th of 2023. Now, be aware that there are dangers to self-representation. So if you want to represent yourself, there's some dangers to representing yourself. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself or waive your right to have an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, in bold letters, it states, defendant's choice, mark initials next to only one choice. Now, if your choice is to hire your own attorney, then you will place your initials on the first line to the left. If your choice is to, if you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in this case, then you will put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to have an attorney or give up your right to have an attorney, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines at the bottom of that document, the first document, then you will sign your name on the line that is titled defendant, and you will date it today's date, and today's date is December 5th of 2023. Now, the second page, which is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial, reads as follows. It states, I have been at, now this is the document that will be signed by individuals who will be waiving their right to an attorney or giving up their right to have an attorney. And you'll be representing yourself. So if you're not waiving your right to have an attorney or giving up your right to have an attorney, you don't have to read and sign this document. Only those who will be waiving their right to have an attorney will be reading and signing this document. I'll go over this document with you, and it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. That meaning that self-representation is representing yourself. My waiver is voluntarily. Voluntarily means that nobody's forcing me to sign this form or waive my right to attorney. I'm doing it of my own free will. And it is intelligent made. In essence, I know what I'm doing. Okay. Furthermore, I have been advised this 5th day of December of 2023 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I am financially unable to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that is your choice, then you will sign your name on the line that is titled defendant, and you would date it today's date, December 5th of 2023. Now, as a defendant in the criminal case, you have a right to have a trial by jury. Now, when those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that is presented. They will listen to the oral arguments, and then they will retire to deliberate. And then they will decide whether to find you not guilty or guilty of your charge. You also have a right to waive, which means to give up your right to have a trial by jury. And if you waive or give up your right to have a trial by jury, you will not be having a trial by jury. However, your case will come before the court in one of 3 ways. One way it becomes before the court or before the judge is by way of a trial without a jury. It will be a bench trial. A bench trial means that you will be having a trial by judge only. The judge will listen to the evidence that is presented. The judge will listen to oral arguments. The judge will decide, after listening to all of the oral arguments and listening to all of the evidence that is presented, the judge will then decide whether or not to find you not guilty or guilty. The other way that your case will come before the judge, can come before the judge, is by way of a plea bargain agreement. A plea bargain agreement is an agreement that you have worked out with the state of Texas or with the district attorney to settle your case. It can come before the judge by way of an unagreed plea bargain agreement. What that means is you've talked to the state, you have been unable to reach an agreement with the state of Texas to settle your case. And so therefore you want the judge to set the punishment. Or you have talked to the state and you have been able to come to an agreement to settle your case. We call that an agreed plea bargain agreement. Now, if you have an agreed plea bargain agreement with the state, then they will come before the judge. The judge could either accept or reject the plea bargain agreement. Now, if the judge rejects the plea bargain agreement that you have made with the state, then you can tell the judge, or you can withdraw or take back your plea, which means you can tell the judge, well, judge, since you're not accepting the plea bargain agreement that I have with the state, I'm taking back my plea. a plea of guilty or no contest. You can do that if the court does not follow the agreement. Now, if the court does follow the agreement and within 30 days you decide, hey, I think I've been wrongfully convicted, or I want to appeal this case, then you would have to get permission from the judge that followed the plea bargain agreement. And if the judge gives you permission to appeal your case will then go up to the third floor, which is the Ninth Court of Appeals, and they will review your case, and they will decide either to grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to another court, a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas, and it is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review, and I'll explain to you what that means. Pro se means you'll be filing this petition on your own without the assistance of an attorney. That's what pro se means. And then you'll be petitioning the Texas Court of Criminal Appeals to review your case to see, one, whether or not your appeal should have been granted, whether or not you were wrongfully convicted, or whether or not this court committed an error by convicting you. They can do one or two things. They can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty, or they can send the case back to the Ninth Court of Appeals, or they can send it back to this court in order this court to give you a whole new trial. Or so the other thing is, if they deny your pro se petition for discretionary review, then at that point your conviction will stand. Now, as a defendant in the criminal court, you not only just have a right to have an attorney, have a right to have trial by jury, have a right to have what is called a bench trial, or have a plea bargain agreement, or a agreed or unagreed plea bargain agreement. You also have a right to have witnesses to come to court and testify in court at that chair that I'm pointing at, that has the microphone before it. It's called the witness stand. And what witnesses do, they can testify for you or against you. If you have an attorney, if you represent yourself, witnesses can be asked questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to testify in your case. And by doing so, if you waive or give up the right to have witnesses to testify in your case, that just simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses in your case, because they will be calling witnesses in your case. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. The state or the district attorney's office, the government, cannot force you to testify in your case if you invoke your Fifth Amendment right against self-incrimination. So if you exercise your Fifth Amendment right against self-incrimination, they can't force you to testify. Now, you can waive or give up your right, your Fifth Amendment right against self-incrimination, and by doing so, you will be testifying in your case. Now, you also have a right to have what is called discovery. Discovery means you have a right to see the evidence that the state has against you or will be using against you in your case. Now, you have a right to see documents. You have a right to see witness statements, police reports, lab reports. You have a right to see photographs, listen to audio recordings or video recordings. And you also have a right to see documents and instruments that they may be using. Now, you can waive or give up that right as well, which means if you waive or give up the right, that means you will not have access to that information. Now, everyone here for court, you're here because you have been arrested by the you have been arrested on this case, and you have been given you're out of jail on what we call bond. You're either out on what is called a cash bond, which means you pay the full amount of the bond to get out of jail, or you're out on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance, promising to appear in court for your court appearance. Now, every day that you spent in jail, that jail time can be used as credit toward your fine and court costs. So, for example, let's say you spent 5 days in jail and then you got out on bond, and you are talking to the prosecutors, or your attorney's talking to the prosecutors, and they are offering you to serve 5 days in jail. That simply means that you will not have to serve 5 days in jail because you've already spent 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if they offer 7 days in jail and you spent 5 days in jail, that simply means that you don't have to do 2 days in jail because you're getting credit for the 5. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. So, for example, you spent 5 days in jail. Every day that you spend in jail, $100 will go toward your fine and court costs. So, for example, you spend 5 days in jail, that's $500 that can go toward your fine and court costs. So, if the state is offering you fine and court costs of $500, that simply means you don't have to pay $500. Why? Because you spent 5 days in jail, and your 5 days in jail is $500. So, therefore, the fine and court costs will be taxed and returned. Now, if they offer $700, you spent 5 days in jail, we're going to simply take 5 from the 7, and that leaves $200 that's left. Now, we normally require that you pay it on that day, but however, if you can't pay it on that day, then we could put you on a payment plan. That is, we could allow you to pay it off in monthly installments until it's paid off. Now, if you can't pay it off in monthly installments, well, we can convert your fine and court costs to what is called community service. Community service is you'll work at a nonprofit organization in our community, and every 1 hour of community service that you perform at a nonprofit organization, $12.50 will go toward your fine and court costs. So, for example, in an 8-hour day, you work 8 hours in a nonprofit organization, that's $100 that will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. So if you haven't been in trouble before, you may qualify for this program. And in this program, what they will do, they will dismiss your case. Once they dismiss your case, you complete the case, you can get it expunged from your record. Expunged means wiped off, erased, or deleted from your criminal record. Now, in order to qualify for the program, it has to be your first time getting in trouble. You have to have an attorney to help you make the application out to the district attorney's office. And third, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. Now, Jefferson County also has a program that is called Veterans Court. It is a program for veterans only. That program is part of the pretrial diversion program as well. And with that program, if you're a veteran, if you get into the program, then if you complete the program, your case will be dismissed, and you can get what is called a non-disclosure. A non-disclosure, lack of a better term, it basically means your record is sealed. Now, and that is sealed to the public. It does not mean that the government cannot get it, okay? Because the government can have access to the records, the police department, just the government They have governmental agencies that can have access, but the general public cannot have access. So the record is sealed to the general public. Now, if you're if you're a veteran of any one of the branches of the military, and if you're interested in that program, just let us know. We have some brochures that we can give to you. And you can make contact with the district attorney's office so that they can see if you qualify for that program. Now, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. In that program, the program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over and over. And so the way we address recidivism is through the program that we have that is called the CSI program. With the program, we have partnerships with local agencies. One of the partnerships that we have is we have a partnership with Spindletop. Now, the young people that I pointed out to you earlier, they're from Spindletop, and they're going to come to you in a few minutes and tell you a little bit about the program that Spindletop has to offer. Now, the program, basically, what Spindletop basically will do, let me do this here. In order to qualify for the program, you do not have to be insane or incompetent. You could simply suffer from depression or anxiety or any other host of mental illnesses. Spindletop has expertise to address it. Now, with the Spindletop program, they can do a private interview, an assessment. They can develop a treatment plan, either outpatient, inpatient, depending on your mental health needs. Spindletop also has a program that is called ATAR. And ATAR stands for Addiction, Treatment, and Recovery. It's a drug and alcohol recovery program. So if you have any issues with drugs or alcohol, Spindletop has an ATAR program, and our local Drug and Alcohol Council has a program that is called OZAR. OZAR stands for Outreach, Screening, and Referral. Both of those programs, ATAR and OZAR, are recovery program, and they can do private screening, an assessment, and develop a treatment plan, outpatient, inpatient, and you refer to a program for either outpatient or inpatient treatment. If you are unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. Golden Triangle Empowerment Center has a program that is called, Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you select, then they will help you or assist you to get a job in the area that you're trained in. If you have not graduated from high school and you'd like to get your GED or your graduate equivalency diploma, well, CICE has a program for the GED. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but a little time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes because they have too much to lose. And so I always like to say that when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, then we will make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just please let us know. And we have brochures that we can give to you that will assist you at getting in any one of these programs. And the other benefit from the program is this. All of these programs can be used as community service. So for example, if you was ordered to pay a fine, you could not pay your fine, we converted it to community service. So while you're maybe in a program with Spindletop, every 1 hour you're in that program, $12.50 will go toward your fine and court costs. Or if you're working on your GED, every hour you're in that program, $12.50 will go toward your fine and court costs. Or maybe you're getting mental health treatment or drug and alcohol treatment every 1 hour of counseling or treatment. $12.50 will go toward your fine and court costs. So I like to say with this program, we do not just kill 2 birds with 1 stone, you're giving 3 birds with 1 stone because you're in the program, you're paying your fine and court costs, and 1 hour is going toward community service. So you're doing one thing, but you're getting credit for 3. Now, at this time, we're going to have Chris, Gabby, and Deputy Hinton will come forward and tell you a little bit about the program that they have to offer with Spindletop.
Thank you, Your Honor.
Thank you. Welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission with the sheriff's department. I'm here with my coworkers, Chris and Gabby. Now, both of these ladies are both qualified mental health professionals. The reason we're all 3 here this morning is because the judge cares about every single person that comes for the bench. What the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, such as use disorders, or sometimes it's the lack of community resources.
Maybe we can understand that being in the court system, being here, that it kind of interrupts your and it's not stressful already, the life stuff that you have going on right now. And so what we're just trying to do is trying to be as possible to provide you the resources. And whenever he says mental health, he means things like anxiety, depression, things we don't want to deal with everyday basis.
So maybe this is your first time to be here, maybe it's your 10th time to be here. There's still hope. In fact, what we're offering you today has the ability to change your life. We're going to need something from you. We're going to need you to share that need with us. And when you first came in, Gabby gave you a document. That document we'll use, and she'll tell you how you can actually share that need with us very promptly.
So the document that you got is HIPAA protected. That means that only I'm going to see it, or my coworker here. One of us are going to contact you, and that's the only person who's going to see it. Nothing, nobody here, nothing else. Also, the good thing about this form is that it just gives us permission to contact you once. We'll probably have to text out for you if the text is not. If Ron doesn't receive text, please let us know, and we'll try to reach out. We want to get in contact with us possibly can for you, and then we'll figure it for you. One of the things that will help us see what resource we need is the most important thing is on that document. You see it, it's probably gonna be a checkbox up there that says which resource that you need. And there's a quick space that we use that is on that says other. If you'd like to fill in that resource, please do so. And if you'd like to talk with private video also, you can check the bottom which is also a resource in itself, and understanding a lot of times what people need is support. We all need support. If you want to keep reaching out to us, if you want to keep working with us, we will work as hard for you as you do for yourselves, and you all showed up with it. We already know you work hard for yourself. You're here.
Also, I want to hand you this flyer before you leave here today. On the back, it tells you a little bit about the advantages of participating, but it also has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help.
So the important thing about that 1-800 number is that it is almost daily. It's also 24/7. We recognize a lot of people come important in Jefferson County that are not necessarily from this area or anywhere close to it. It doesn't matter where you're from. It doesn't matter if you're here for yourself or as support for somebody else. What matters is that you're here. If you need something, let us know, and we'll do our very best to find it, regardless of where you're from or what you need. There's a family member who needs it also on there, and you can also include that on the sheet that I gave for anybody. It's for everybody else. Well, give us as a giant meeting. If you need information, we will get it from you.
just shortly, the court is gonna go into recess. When it does, we'll be able to come out there, we'll visit with you, we'll pick up those documents. I'll also get this flyer in each hand, so you'll have this one, and this one. So, thank you very much.
Okay.
Thank you, Your Honor.
Thank you, Deputy Hinton, Chris, and Gabby. Okay, now, ladies and gentlemen, the court is going to go into recess, and before the court goes into recess, we need to give you some instructions. Now, if you need any help with the paperwork that you have, we have our court personnel who's here, who will be able to help you. Now, it's going to take us a little time to pick up the paperwork from you. Now, if anyone needs to use the restroom, there are restrooms right outside this courtroom. The male restroom is in front of County Court at Law Number 3, which is right next door to us in the hall. And on the opposite side of the hall is the female restroom in front of the 172nd District Court. Now, please do not leave the courthouse, because if you leave the courthouse and if we call your name and you're not here, then your bond can be revoked. And if your bond is revoked, then they'll issue a warrant for your arrest. So at this time, we're going to go into recess. We want to make sure that everybody's phone is off and be quiet. Let's not make a bunch of noise or anything. And so at this time, we have our court personnel here. If you need any help, just simply raise your hand. And when they go around to pick up the clipboards, they'll be happy to help you. So at this time, the court will be in recess. You minute. Yeah. You have his reset?
Yes, sir.
Okay, Mr. Armstrong, this is cause number M 332-624, case of style state of Texas versus Michael Paul Armstrong. Mr. Armstrong, would you please raise your right hand? Mr. Armstrong, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Now, Mr. Armstrong, I have before me a document that is titled Jefferson County Affidavit. Judge's explanation of rights to defendants without attorney. You recognize this document?
Yes, sir.
Now, Mr. Armstrong, is this your signature on this document?
Yes, sir. Yes, sir.
Let me do this here, Miss Bradley Jackson, get that back to him. He needs the second line that we've been informed that you've hired Ralph Kimler. Is that correct?
Yes, sir. There was a mix up with the payment, but I made partial.
Yeah, but I think he contacted the court, right?
Okay.
He did, yes.
Okay, you need to put your initials on the second line.
Yes, sir.
And the name of the attorney on the line to the right.
Yeah, I didn't have that verified before I committed it.
Okay, now is everything on that document true and correct to the best of your knowledge?
Yes, Your Honor.
Okay. Okay, your case is being reset. You gave me his reset date. What is that?
February 14th.
Okay, your case is reset to February 14th. Stay in contact with your attorney, Mr. Kimler, and your bondsman. You're free to go and you have a blessed day. Next case is cause number 23CCCR 0868, case is style of the state of Texas versus Kerry Wayne West Jr. Your name is Kerry Wayne West Jr. Mr. West, I have a dismissal here from the Jefferson County District Attorney's Office. And I'm signing this dismissal. You'll be able to get a copy of this dismissal in about a few minutes. Gonna have a seat in that chair by the wall. Mhm. Yeah. 23CCCR 1218, case and style of state of Texas versus Tamar Devion Smith. Yes, stand before the bench. Mr. Smith, your full name is Tamar Devion Smith.
Yes, sir.
Mr. Smith, would you please raise your right hand? Mr. Smith, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Smith, you may put your hand down. How are you doing, Mr. Smith?
Your Honor, still.
I'm doing fine. Thanks for asking. Mr. Smith, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled defendant?
Yes,
And are these your initials on the line stating you want to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea Proceeding in Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that is titled defendant?
Yes, sir.
Mr. Smith, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay. Mr. Smith, I read your answers. Based on your answers, I'm going to have you to take a seat, and one of the prosecutors is going to come out and talk to you. All right, just have a seat. Next case is cause number 23CCCR 1548, case of style of state of Texas versus Brandon Dodd. Mr. Dodd, your full name is Brandon Dodd.
Yes, sir.
Mr. Dodd, would you please raise your right hand? Mr. Dodd, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Dodd, you may put your hand down. How are you doing, Mr. Dodd?
How are you?
I'm doing fine. Thanks for asking, Mr. Dodd. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line stating you would like to waive your right to attorney and to represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for purposes of enter guilty plea or proceeding in trial. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Dodd, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Dodd, just have a seat, and one of the prosecutors is going to come out and talk to you. Next case is cause number 23CCCR 0760. Case is styled the state of Texas versus Javante Turner. Mr. Turner, your full name is Javante Key Turner.
Yes.
Mr. Turner, would you please raise your right hand? Mr. Turner, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Turner, you may put your hand down. How are you doing, Mr. Turner?
Right.
That's good. And Mr. Turner, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line?
Yes.
It's titled defendant, and are these your initials on the line stating you want to reset your case so that you can hire your own attorney? And Mr. Turner, before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Turner, just your case is going to be reset to give you an opportunity to hire an attorney. Have a seat in that chair by the wall, first chair, and when the court coordinator is ready, she'll call you to the window. Next case is cause number 23CCCR 0772. Case is styled the state of Texas versus Michael Daw. Mr. Daw, would you please come forward? Mr. Daw, your full name is Michael Daw? Mr. Daw, would you please raise your right hand? Mr. Daw, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Daw, you may put your hand down. How are you doing, Mr. Daw? You doing all right? Now, Mr. Daw, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line stating you would like to have your case reset to hire your own attorney? Okay, now, Mr. Daw, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct? Okay. Now, Mr. Daw, your case is going to be reset to give you an opportunity to hire your attorney. But before our court coordinator give you your reset, I need to give you some bond conditions. Mr. Phillips, could you hand him these bond conditions? Mr. Daw, these are some bond conditions that I'm going to go over with you. Mr. Daw, did you see the title that's on this document that is titled Standard Bond Conditions in County Court Law number 2? Yes, sir. Okay. Now, it reads as follows. Following the return of a criminal information in County Court Law number 2 of Jefferson County, Texas, all bail bonds executed for release for any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Yes. Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol when the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Yes. Now, condition number 3 does not apply, and condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states as follows. The defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? Yes, sir. Now, Mr. Daw, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. Do you understand that? Okay, now, Mr. Daw, you're going to have a seat in that first chair by the wall. And when the court coordinator is ready, she's going to call your name. You'll be free to go on your blessed day. You welcome. Daw. Yeah, he's. Next 3 cases are cause numbers 23CCCR 2034, cause number 23CCCR 2035, and cause number 23CCCR 2040. All 3 cases are style of state of Texas versus Evan Escain. Mr. Escain, your full name is Evan Escain. Mr. Escain, would you please raise your right hand? Mr. Escain, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Escain, you may put your hand down. How are you doing, Mr. Escain? That's good. Mr. Escain, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line stating you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Escain, before you sign and initial these documents that I just showed you, Did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. S. Kane, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will also be given information to contact her. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair by the wall.
Michael Dahl.
Next case is, well, the next two cases are cause numbers 23 CCCR 0468 and cause number 23 CCCR 1856. Both cases are styled with State of Texas versus Sean Wyatt Miller. Mr. Miller, would you please come forward? Mr. Miller, your full name is Sean Wyatt Miller?
Yes.
Mr. Miller, would you please raise your right hand? Mr. Miller, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Miller, you may put your hand down. How are you doing, Mr. Miller? That's good. Mr. Miller, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Are these your initials on the line stating you'd like to apply for a court-appointed attorney? Also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, there is a signature above the line that is titled Defendant. Is this your signature? Now, Mr. Miller, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Now, Mr. Miller, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Court coordinator will give you information to contact your attorney, and your attorney will be given information to contact you. But before the coordinator give you that information, I have some bond conditions that I need to give to you. Mr. Miller, the document that has just been handed to you is titled Standard Bond Conditions in County Court at Law Number 2. You see that title?
Yes.
Okay, I'm going to go over these bond conditions with you. And it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3 and 4 does not apply. However, condition number 5 does apply. Condition number 5 reads as follows. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that?
Yes.
Now, Mr. Miller, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. And if a warrant is issued for your arrest, you'll be placed in the arrested and placed in the Jefferson County Jail. Do you understand that?
Yes.
Okay. Now, just have a seat. in that first chair by the wall. And when the court coordinator is ready for you, she's gonna call your name. And once you finish, you be free to go and you have a blessed day. Who did we have as his attorney appointed? Yeah, was it Provo? I mean, was that Provo? Okay.
Evan?
Next case is called number 23 CCCR 0880. Case is style of State of Texas versus Angela Marie Stansberry.
I'll call you now. You got to take me a minute.
Ms. Stansberry, your full name is Angela Marie Stansberry?
Correct.
Okay, Ms. Stansberry, would you please raise your right hand? Ms. Stansberry, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing, Ms. Stansberry?
Very well.
You doing very well? That's good. Now, Ms. Stansberry, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, Your Honor.
And this is your signature on the line that's titled Defendant?
Yes, Your Honor.
At the top of this document, or at the bottom of this document, there's a set of initials on a line next to a box that states that you would like to apply for a court-appointed attorney. Did you place your initials on this line?
Yes.
Also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, Your Honor.
And on page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, Your Honor.
Now, Ms. Stansberry, before you signed and initialed these documents, did you read the documents?
Yes, Your Honor.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
And Ms. Stansberry, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will also be given information to contact him. But before our court coordinator give you that information, I need to give you some bond conditions. The bailiff is going to hand you a set of bond conditions. I'm going to go over these bond conditions with you. Now, do you see the title that states standard bond conditions in County Court Law Number 2? Okay, I'm going to go over these bond conditions with you. And it reads as follows. Following arrest and or accusation in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, Your Honor.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 does not apply. However, condition number 4 does apply. Condition number 4 applies because you have an offense which is listed as a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. In essence, you have a DWI second. And condition number 4 states as follows. A defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, or said device shall be installed at the defendant's expense with written verifications of such installation being submitted to the court on or before That'll be the 10th day after today. Yes,
I had that installed 2 weeks ago.
good.
It's already,
Okay, well,
I
let's,
can get proof if need be.
yes, you need to, when you get some proof, you need to either email
Mr. Evans?
the receipt to our court, or you can fax it, or you could bring it in person. The court coordinator, can tell you, you get the information if you want to fax it, or if you would like to email it. Okay, so just have a seat in that first chair, by the wall, and then when the court coordinator is ready for you, she's gonna call your name. Once she calls your name and finish with you, you'll be free to go, and you have a blessed day. Okay. Agent Carol Joseph Paddock. Your full name is Adrian Carol Joseph Paddock.
Yes, sir.
Ms. Paddock, could you please raise your right hand? Ms. Paddock, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Paddock, you may put your hand down. How are you doing, Ms. Paddock?
All right, question.
I'm doing fine. Thanks for asking, Ms. Paddock. I have before me a document that is titled, Judge's Explanation of Rights of Defendants Without Attorney. Recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? And are these your initials on the line stating you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Paddock, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Paddock, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Just have a seat at the wall. He must not showed up. Guess he didn't show up. Next case is cause number 23CCCR 1078, case of style of state of Texas versus Elijah LaShawn Lewis. Mr. Lewis, your full name is Elijah LaShawn Lewis. Mr. Lewis, would you please raise your right hand? Mr. Lewis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lewis, you may put your hand down. How are you doing, Mr. Lewis? Oh, I'm doing fine. Thanks for asking. Mr. Lewis, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? And are these your initials on the line stating you would like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Now, Ms. Lewis, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Ms. Lewis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Lindsay Scott. Attorney Scott will be given information to contact you, and you will be given information to contact her. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that first chair by the wall.
Thank you.
You're welcome. Next case is cause number 23CCCR 1012. Case is styled the state of Texas versus Cheryl Moet Booker. Ms. Booker, your full name is that Cheryl Moet Booker?
Sure.
Sherelle Moet Booker? Ms. Booker, would you please raise your right hand? Ms. Booker, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Booker, you may put your hand down. How are you doing, Ms. Booker?
Great.
That's good. Ms. Booker, I have before me two documents. Let me do this here. Is this another one? Oh. Let me do this here. Off record. I was looking at your affidavit of indigence. Let me do this here. When you're Okay, let me just make sure everything. Now, Miss Booker, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Are these your initials on the line saying you'd like to apply for court-appointed attorney?
Yes.
I also have a document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes.
On page 2 of this same document, they talking to the prosecutors,
Both of them?
both of them.
Okay,
Yeah.
that's the next question.
And do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant's signature?
Yes.
Now, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Let her sit right down, you can read out.
Okay, now, Ms. Booker, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that is appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Once you get that information from the court coordinator, you will be free to go and you have a blessed day. Please have a seat in that board. Yeah, that chair by the wall. Next case is cause number 23CC 1548. Case is styled the state of Texas versus Brandon Dodd. Mr. Dodd, would you please come forward? Mr. Dodd, would you please raise your right hand? Mr. Dodd, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God? Mr. Dodd, you may put your hand down. How are you doing, Mr. Dodd? I'm doing fine, thanks for asking. Mr. Dodd, state is represented in this case by attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, and yourself?
I'm doing fine, thanks for asking. Now, Mr. Dodd, you have a right to have a court reporter to type up everything that's being said. However, you can, if you desire, to waive or give up your right to have a court reporter. You know, do you waive or give up your right to have a court reporter? Okay. Now, Mr. Dodd, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Dodd, it alleges that you, Brandon Dodd, on or about May 14th of 2023, while you were in Jefferson County, Texas, that you was May 14th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of possession of dangerous drugs. Mr. Dodd, did you understand what you've been charged with? And to this charge, Mr. Dodd, how do you plead guilty, not guilty, or no contest? How do you plead? Guilty? Do you plead no contest? Or
No, I think I could not.
no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Okay, Mr. Dodd. Now, I have before me a couple of documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document? And is this your signature online as titled defendant? And are these your initials on the line that states you'd like to apply, that you would like to waive your right to an attorney and represent yourself? I also have another document that's titled Waiver of Counsel for Purposes of Entering Guilty Plea of Proceedings Trial. Is this your do you recognize this document? And is this your signature on the document that's titled on the line that's titled defendant? I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also referred to as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there are two sets of initials. One set of initials is on a line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document? The second set of initials is on a line that's below a paragraph that is titled Discovery and Admonishment, and it is next to a statement that reads as follows: I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest. Did you also place your initials on this line?
Yes, sir.
Now, Mr. Dodd, I also have another document. This document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Dodd, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Dodd, are you a citizen of the United States? State, I have before me State's Exhibit Number 1. State, would you like to offer State's Exhibit Number 1 in evidence?
Yes, Your Honor.
Mr. Dodd, the state is offering State's Exhibit Number 1 to be introduced into evidence. State Exhibit Number 1 is the document that you first acknowledged. And this is the same document that have your initials on the two locations on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence against you in your case? Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Dodd, is there any evidence that you are currently mentally incompetent to stand trial? Do you have any mental illnesses that are affecting your ability to understand what is going on in this case? Okay, and you are aware of what you're doing. Okay, Mr. Dodd, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a State, do we have a plea bargain agreement in this case?
Yes, Your Honor.
And what is that agreement?
That agreement is for a plea of guilty or no contest. The state has offered 1 year deferred probation with a $300 fine and 50 hours community service.
What is the court cost in this case?
377.
Okay. Okay, Mr. Dodd, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $377 plus a probation fee, $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $145 a month. Will you be able to pay the $145 each month? You will also be required to perform 50 hours of community service and adhere to the other standard terms and conditions of this probation. Now, Mr. Dodd, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Mr. Dodd, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Dodd, you ready for him? Just have a seat, and then when the court coordinator is ready for you, she's going to call you up. Now, Mr. Dodd, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure, and you can talk to an attorney about filing a non-disclosure. All right? Just have a seat. You have a blessed day. You can stand right here?
Yes.
All right. Mr. Smith, your full name is Tamar Devion Smith?
Yes, Your Honor.
Mr. Smith, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Smith, you may put your hand down. Mr. Smith, the state is represented in this case by Attorney Sarah Staub. Attorney Staub, how are you doing?
Good, Your Honor.
Now, Mr. Smith, you have a right to have a record made of this proceeding. That is, you have a right to have a court reporter to type or dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter. You waive or give up your right to have a court reporter? Okay. Now, Mr. Smith, I have before me a document that is titled that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Tamara Devion Smith, on or about June 13th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Mr. Smith, do you understand what you've been charged with? And to this charge, Mr. Smith, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Now, Mr. Smith, I also have before me a document that is titled, where is it? Mr. Smith, I have before me a document that is titled, keep that, that's for the next. That's titled, Judge's Explanation of Rights to Defense without Attorney. Recognize this document? And is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to waive your right to attorney and represent yourself? I also have a document that is titled Waiver of Counsel Purposes Entering a Guilty Plea Proceeding Trial. You recognize this document? And is this your signature on the line that's titled defendant? I also have a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? It is also labeled as State's Exhibit Number 1. On page 2 of this document, there are 2 sets of initials. First set of initials, TS, are on the line next to a box to check no contingent, which means no contest. You place your initials on this document. The second location of this second set of initials is located below a paragraph that is titled Discovery Admonishment and is next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials on this line as well? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature? On the next document that's titled trial court certification of defendant's right of appeal, you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Smith, are you a citizen of the United States? State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment statement. Would you like to offer State's Exhibit Number 1 into evidence?
Yes, Your Honor.
Mr. Smith, the state is offering State's Exhibit Number 1 into evidence. State's Exhibit Number 1 is the document that you just acknowledge. This is the same document that have your initials on the 2 locations on page 2 and your signature above the line that is titled defendant on page 3. State would like to use this document as evidence against you in your case. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Smith, is there any evidence that you are currently mentally incompetent to stand trial? Mr. Smith, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Your Honor,
And what is that agreement?
1 year of deferred probation, a $300 fine, and 30 hours of community service.
Yeah. What is the court cost in Mr. Smith's case?
277.
277. Hey. Okay, Mr. Smith, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll be required to pay a probation fee of $6 each month, a year analysis fee of $15 each month, and reimbursement fee of $15. That is, you'll be required to pay this in monthly installments of $136 a month. Will you be able to pay the $136 each month?
Yes, Your Honor.
You will also be required to perform 30 hours of community service and adhere to the other standard terms on condition of this probation. Mr. Smith, do you understand the state's offer? Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer? Mr. Smith, I'll follow the plea bargaining agreement. Okay. Now, Mr. Smith, I'll follow the plea bargaining agreement that you have entered into with the state. And Mr. Smith, if you successfully complete this probationary period, this case will be dismissed. It will not appear on your record as conviction. You may qualify for non-disclosure. You can talk to an attorney about a non-disclosure. Now, Mr. Smith, this will conclude your case. And just stand right here in front of our court coordinator. Once you're finished with the coordinator and the bailiff, you'll be free to go. And you have a blessed day.
You as well.
You're welcome. Thank you. Scott Court Law number 2 is back in session. I'm gonna start in the back. First case is cause number 23CCCR 0472. Case is Solid State of Texas versus, is it Helius S. Yat? Helius Yat was scheduled to be in court this morning at 9 a.m. for the court's arraignment docket. At or about 9 a.m., the court's barely called the name of Helius Yat at the courthouse door. Helius Yat did not answer. Helius Yat has not appeared in court since the court has been in session. The time now is 11:49 a.m. on today's date of December 5th of 2023. Ms. Bailiff, would you please call the name of Helius S. Yat at the courthouse door?
Response, Your Honor.
Helius Yat's name was just called again at the courthouse door. Helius Yat did not answer. A reasonable time has passed to give Mr. Yat an opportunity to appear in court. He is not appearing in court. State, do you have a motion? That motion will be granted. Helius Yat's bond will be forfeited and a warrant should be issued for his arrest in cause number 23CCCR 0472. Next case is cause number 23CCCR 0498. Case is filed in the state of Texas versus Jessica Danielle Herring. Jessica Herring was scheduled to be in court this morning for the court's arraignment docket at or about, at 9 a.m. At or about 9 a.m., the court's barely called the name of Jessica Herring at the courthouse door. Jessica Herring did not answer. Jessica Herring has not appeared in court since the court has been in session. The time now is 11:53 a.m. on today's date of December 5th of 2023. Ms. Bailiff, would you please call the name of Jessica Herring at the courthouse door?
Jessica Herring. Jessica Herring. I respond, Your Honor.
Jessica Herring's name was just called at the courthouse door. Jessica Herring did not answer. A reasonable time has passed to give Ms. Herring an opportunity to appear in court. She has not appeared in court. State, do we have a motion? That motion will be granted. Jessica Herring's bond will be forfeited and a warrant shall be issued for her arrest in cause number 23CCCR 0498. Next case is cause number 23CCCR 0816. Case is filed in the state of Texas versus Demetrius Miles. Demetrius Miles was scheduled to be in court at 9 a.m. on today's date for the courts of Raymond docket at or about 9 a.m. The court's bailiff called the name of Demetrius Miles at the courthouse door. Demetrius Miles did not answer. Demetrius Miles has not appeared in court since the court has been in session. The time now is 11:54 a.m. on today's date of December 5th of 2023. Ms. Bailiff, would you please call the name of Demetrius Miles at the courthouse door?
Demetrius Miles. Demetrius Miles.
Demetrius Miles' name was just called again at the courthouse door. Demetrius Miles did not answer. A reasonable time has passed to give Demetrius Miles an opportunity to appear in court. State, do you have a motion? That motion will be granted. Demetrius Miles' bond will be forfeited, and a warrant should be issued for his arrest and cause number 23 CCCR 0816.